All right, if I could have everyone's attention, we'll go ahead and start. Our guest today is Professor David Bernstein. He's a professor at George Mason University, among many other things. He has written the book, Rehabilitating Lochner. I hope you'll explain the artwork on the cover. I don't know if everyone will understand it, but basically most of the things that you've heard about Lochner probably need a little bit of nuance, at least. So we have two wonderful speakers today who will be able to provide that nuance. Providing commentary to Professor Bernstein's remarks is our own Professor Sophia Lee, who is one of my favorite people here at Penn, kind of implausibly, I think, but one of my mentors, and I would maybe venture as far to say a friend in some respects. She has a JD and her PhD in history from Yale, and she clerked for the Honorable Kimball Wood of the Southern District of New York. So with that, I'll turn it over to Professor Bernstein.
Thank you, and thanks for coming today. So how many of you have taken con law already, or everyone? Almost everyone? No. Most of you, but not all of you. So let me give you a little bit more detail than I would if you had all taken it already. So Lochner versus New York was a case in 1905 in which the Supreme Court held that a New York state law that prohibited bakers, only bakers, from working more than 60 hours a week in a bakery was unconstitutional. They said it violated the right to liberty of contract, which they found in the Due Process Clause of the 14th Amendment. No person shall be deprived of life, liberty, or property without due process of law. This clause nowadays is used to protect rights such as the right to terminate pregnancies in Roe v. Wade, the right to privacy in Griswold versus Connecticut, but 100 plus years ago it was thought to also protect liberty of contract against arbitrary government regulation. Lochner is a really notorious case, and it plays a very important but yet very strange role in American constitutional debate. So just for example, in 2012, in April, President Obama, speaking just before the Supreme Court was about to hear the big Obamacare case, said he expected the Supreme Court to uphold the law because, quote, "we have not seen a court overturn a law that was passed by Congress on an economic issue like health care. And I think that most people would clearly consider commerce. A law like that has not been overturned, at least since Lochner," right? Okay, that's not the most coherent sentence. But the point is, he was saying that the court, everyone knows that the court used to strike down economic legislation, as in Lochner they don't do it anymore, so the law will be upheld. Now the reason this is a little bit strange is because the Obamacare litigation was based on a reading of the Commerce Clause of the Constitution, which limits Congress to regulating interstate commerce, and as the court has held, or things affecting interstate commerce. As we've just seen, Lochner was based on the Due Process Clause. So we all know in law that you look at the provision of a contract of the Constitution that you're aiming at, and different provisions have different meanings. So what does one have to do with the other? And the other thing that's odd is that the Due Process Clause, I summarize as no person shall be. It's actually no state shall deprive any person of life, liberty, or property without due process of law. But of course, Obamacare was a federal law, not state law. So why is President Obama, like many other people, bringing in Lochner in a context where it doesn't seem to have much salience? And I'm going to address that issue while I do two things. First, I'm going to address some myths about Lochner and also about the case itself, while also addressing some myths about Lochner's opponents and proponents in the contemporary time when the case was decided. So let's start with myth number one, which is that Lochner and other cases protecting liberty of contract were a result of the Supreme Court trying to impose laissez-faire on the United States. The fact is, the Supreme Court did occasionally overturn laws regulating contracts as violations of liberty of contract, but for the most part, they actually upheld almost every law that came before them. In fact, there were about 13 different cases involving maximum hours laws, including Lochner. The Supreme Court upheld 12 of them that came before it, except for Lochner. So if the Supreme Court was trying to impose laissez-faire, it was doing a pretty poor job of it. And that suggests that there may have been some special things about how the law in Lochner was drafted and some facts about Lochner itself that may have made a difference. And I'd be happy to talk about it. That's what my book argues. I'd be happy to talk about that more. The second thing that one often hears is that Lochner was the product of judicial formalism, that they had this abstract notion of liberty of contract and they ignored the poor, suffering working class who needed government regulation to assist them. Now, that one has had a lot of staying power, even though, if you actually read the opinion closely, not even that closely, just read the opinion, Justice Peckham, who is, in the slide, he's shown knocking down Justice Holmes, who, of course, were a famous descendant of Lochner. Justice Peckham says that in looking through statistics regarding all trades and occupations, it may be true the trade of baker does not appear to be as healthy as some other trades, and is also vastly more healthy than still others. In other words, we want to know, is this really a valid health law that will uphold, like all the other maximum hours laws we're upholding, or are we suspicious this is just arbitrary invasion of people's rights? So let's look at the statistics. Now, you could argue the court should be looking at the statistics. They don't know enough. They're not a democratic branch. We should leave that to the legislature. What you can't argue is that the court did not look at the statistics, and that they were just being formalist. And those statistics, by the way, were in Lochner's brief. It would have suited Peckham's historical reputation if he had cited the brief, because people just seemed to think he was making it up. But he did actually look at the statistics that were in the brief. We also sometimes hear that Lochner, in other cases, protecting liberty of contract, was motivated or were motivated by the justices' social Darwinism. There's literally no evidence for this. It's all based on a misreading of Justice Holmes' dissent. Justice Holmes, in his dissent, said the 14th Amendment does not enact Mr. Herbert Spencer's social status. Herbert Spencer was a famous libertarian. Well, he really knew he wrote. Well, you could call him a sociologist, you could call him an economist, you could call him a philosopher. He did a lot of stuff. He was a polymath, really. And what Holmes says, he was famous for his law of equal freedom. Basically, if you know libertarian philosophy, it encapsulated very well. Law of equal freedom: use your freedom in such a way as doesn't harm anybody else's freedom, and you can do whatever you want. And all Holmes is saying, and if you look at the dissent, if you've read it before, read it again in this context, is, look, we've upheld all sorts of other laws under the 14th Amendment. We've upheld laws banning options trading. We've upheld laws saying you can't work on Sunday. Clearly, the 14th Amendment is not a libertarian document, does not enact Mr. Herbert Spencer's social status. By the time Lochner really became a famous case, in historical retrospect, in the 60s, 70s, and 80s, people didn't know Herbert Spencer from a hole in the head. All they knew that vaguely he's associated with social Darwinism, so they started saying, oh, Holmes, he must have been calling them social Darwinists. Another myth that we hear is that Lochner and other cases invalidating labor regulations illustrate the Supreme Court's hostility to workers and beneficence towards large corporations. This is sort of a simplistic morality tale. It turns out, as you might expect, that things get a little more complicated than that, that often it wasn't workers versus big companies. It was actually some workers versus other workers, some companies versus other companies, right? That's how legislation often works. Different groups gather together in their self-interest, and no one represents all workers, no one represents all business. So Lochner itself, as I describe in the book, was not supported solely by the union, which we might argue, therefore, means they're representing the workers. It was also supported by the big corporate bakeries like Fleischmann's. Why? Because there were a bunch of small immigrant-owned bakeries that were less technologically advanced than the big factory bakeries, and they tend to have these big ovens in their basements, and the ovens were just there. There's just one big oven in your basement. So what do? You put the bread in the oven. There's nothing to do until it comes out. So you take a nap in the next room, then you come back. But that means you're on call for more than 10 hours a day. The big factory bakeries, their workers already only work 10 hours a day, 60 hours a week. So they didn't care. They were happy to have this law to help them put their competitors out of business. Another factor, by the way, motivating the legislation is that these were immigrant-owned bakeries, and people were, elite WASP performers were suspicious that these immigrants were kind of dirty and smelly and were not making healthy bread. So an official New York State factory inspector's report said, oh yeah, these Italian and Jewish-owned bakeries, the Jews and Italians, they don't know anything about cleanliness. Of course, their bakers are filthy. Here's a picture of my immigrant great-grandparents on my father's side. They look perfectly clean to me, but maybe I'm biased. I don't know. So beyond these specific myths, there is a more general mythology that the justices who supported liberty of contract were just evil reactionaries who whose influence has been thankfully purged from modern constitutional law, while their progressive, with a capital P, opponents were enlightened liberals who bequeathed us not only a rejection of economic liberties and federalism, but also modern civil liberties jurisprudence. But in fact, the old progressives of the early 20th century were not like modern liberals like Justice Brennan or Thurgood Marshall or whatnot. They were pretty much uninterested in civil rights and civil liberties. And it tended to be the Lochner line of cases that pioneer protections for the rights of women, African Americans, and certain civil liberties that almost everyone would agree with, like the right to send your kids to a private school. And I could go on and on about that, but still just give you some examples from a series of slides. So who criticized the Bill of Rights for turning the United States into a monarchy of law at the expense of the people? Note, this is not liberty of contract, not the Commerce Clause, the Bill of Rights. Like mom and apple pie here. Was it Herbert Crowley, the great progressive writer, founder of the New Republic, friends with Learned Hand, Louis Brandeis, Oliver Wendell Holmes, or Herbert Spencer of Mr. Herbert Spencer's Social Statics? And the answer is Herbert Crowley, who opposed what he called individualistic limitations of government power. Who wrote that the Due Process Clause protects the right to acquire useful knowledge, to marry, to establish a home and bring up children, and to worship God according to the dictates of your own conscience? This is Meyer versus Nebraska, 1923, language that is still cited favorably by the Supreme Court to this day. Was it Judge Learned Hand, the great progressive judge, or Justice James McReynolds, who is considered the most reactionary of reactionaries on the Supreme Court in the 20th century? And the answer is that it was Justice James McReynolds. This was a case saying, can you teach foreign languages to your children, even in private school, or may the government ban them? The court held 7-2 that you may not ban them, and Justice Oliver Wendell Holmes dissented in Meyer versus Nebraska for the same reasons, more or less, as in Lochner. You can't just do whatever you want. The government should have plenary power to regulate what it feels like regulating. Most of you, even if you don't know the name of the case, you've at least heard vaguely of the infamous case of Buck v. Bell, because it's where Justice Holmes infamously wrote in a case involving mandatory sterilization of people deemed mentally defective that 3 generations of idiots are enough. Now, Holmes' reputation has fallen somewhat, but you might think that Justice Louis Brandeis, who's the great civil libertarian, at least of mythology, would have dissented in Buck v. Bell, and Justice Pierce Butler, who's another one of the reactionary 4 horsemen of the apocalypse, so to speak, who dissented from the various New Deal cases, or would have joined the majority. But in fact, Justice Brandeis joined the majority, and it was only Justice Butler, who is probably both the most libertarian justice and a serious Catholic, who dissented. What's interesting about Brandeis' dissent, it wasn't 8-1 in opinion, so it's not that interesting that he didn't dissent. What's interesting about his non-dissent, but what's interesting about it is that we know from private correspondence that some of the justices dissented really reluctantly. Chief Justice Taft wrote to Holmes. They both were very enthusiastic about eugenics. I'm a little worried about getting my colleagues on board. Some of them are really reluctant to join this opinion. And Brandeis wasn't one of them. And we know he wasn't one of them because a year later he said, here are some examples of the Supreme Court doing the right thing and keeping up with modern times. X v. X, X v. X, and Buck v. Bell. So we thought Buck v. Bell was great. Buchanan versus Warley is sort of an unheralded case that probably no one except me covers in their constitutional law class. But it's a very important case. It involved a segregation law in Louisville, Kentucky, that prohibited blacks from living on the same block as whites and vice versa. And laws along those lines were spreading throughout the South and Midwest at the time. The Supreme Court, in a 9-0 opinion, said this violates the property and contract rights of the buyers and sellers because there's no valid police power reason to stop blacks and whites from transacting in this way. It's an important case, not only because it stopped the spread of these laws, but because this is, for whatever reason, and it's still a little obscure historically, it was right around this time when the Supreme Court started becoming much more sympathetic to the rights of African Americans. Before about 1917, when this case was decided, blacks almost always lost cases before the Supreme Court. After 1917, at least with civil rights cases, they almost always won. Anyway, who drafted a dissent in this case? arguing that segregation laws were inherently reasonable? Was it Justice Willis Vandevant or another one of the so-called four horsemen of reaction on the Supreme Court, or just our friend Justice Holmes? You've probably gotten a sense of the pattern here. It was Justice Holmes. Holmes, again, he said, look, we let the government do all sorts of things. We want to let them we want to let them regulate the hours of bakers. We want to let them regulate reproduction. We also want them to do this. So the general theme here is that the justices who are most likely at the time to want to limit government regulatory power in the economic sphere also were more likely to want to regulate them elsewhere, and vice versa. Either you believe that the police power, so-called, of the states was pretty much unlimited, or you wanted to put some substantial limits against arbitrary legislation. Just the last example. I don't have the last example. All right, we don't need the last example. So the question is, why do all these myths come about? You have to understand that constitutional law circa 1948 looked extremely different from constitutional law circa 1932. Massive changes in doctrine, from a situation where liberty of contract and property rights were protected. There were significant limits on federal power through the Commerce Clause, potentially through the General Welfare Clause, the non-delegation doctrine. Even if you're not familiar with all these terms yet, basically there are lots of limits on government regulatory power in the economic sphere, and there were starting to be some limits on civil liberties restrictions as well. Not surprisingly, if you look at it from a historical perspective, the United States, after facing its two greatest emergencies other than the Civil War in its history, the Great Depression and World War II, people thought we need a lot of government to deal with these things. People are starving in the streets. The Nazis are invading France. We need a strong government to deal with that. Well, the normal thing that would have happened historically is we would have had a big increase of government power, like we had during the Civil War, like we had during World War I, and then when things calmed down, things would have gone more or less back to normal. But this was not, this was an exception to the pattern. Almost everyone who believed in traditional limited government constitutional ideology pretty much died out somehow between the 30s and the end of World War II. Either literally died out or they changed their views. And you couldn't find respectable intellectuals in law offices, in academic faculties in law schools who wanted to go back to the old ways. In fact, you couldn't find people who even really understood it. What was going on there? Non-delegation doctrine, what's that all about? Of course we need big administrative agencies to do all this stuff. Of course we need the federal government to regulate agriculture and labor and all that. So they look back, so instead of being inclined to revisit these things and say, do we go a little too far? Maybe some of these doctrines had some validity. They just say, you know what, all that stuff, it's incomprehensible to us, it's nonsense, it's all a product of reactionary, pro-business, laissez-faire, social Darwinism, and we don't have to treat any of it seriously. It was all just politics, because this stuff, no one sensible could possibly believe this stuff. And they didn't really have a good phrase for this at first. They would call it the jurisprudence of the four horsemen. They would call it the old court, the nine old men, etc. But eventually, for obscure historical reasons, which I, of course, I've devoted to in my book, the obscureness, Lochner became the one case that encapsulated all this. And all of a sudden, in the 1970s, after Lochner not having been that prominent for decades, people started calling the whole period the Lochner era. Why? Because it doesn't matter. If you talk about liberty of contract, you talk about the Commerce Clause, talking about non-delegation, talking about takings clause, it's all just Lochner. So when President Obama, to go back to my original mystery, says if the court invalidates the Affordable Care Act, they're just doing like Lochner. Well, now you understand why. It doesn't matter if it's a due process clause, doesn't matter if it's a commerce clause, doesn't matter if it's a state law, doesn't matter if it's a federal law, it's all just Lochner. Now, this reductio of everything into Lochner could have been challenged, you would think, by the people opposed to emerging liberal jurisprudence, the conservatives. There weren't that many until relatively recently in the academic world, but there were some like Bork and Scalia. But the problem is this: the mythology that the liberals who dominated academia and elsewhere decided to build on was, the New Deal is the greatest thing since sliced bread. The people who were for were always right. People who were against were always wrong. Therefore, the civil liberties aspects that we're now, Fourth Amendment, Griswold, it all comes from people like Brandeis. We're going to ignore cases like Buchanan versus Worley. We're going to ignore Meyer versus Nebraska. We'll attribute, we'll ignore the fact that McReynolds wrote it. We'll just, and so forth. But the old conservatives were always wrong. The old progressives were always right. And now we should build on that and protect civil rights, individual rights. People who objected to this, like Rehnquist and Bork and Scalia, said, instead of saying, no, those cases weren't so bad, well, if Lochner wasn't so bad, well, maybe Griswold isn't so bad either, because they're both unenumerated rights cases. They instead say, no, you guys are being hypocrites. The whole progressive legacy, the whole agenda was to keep judges out of democratic decision-making. You're being hypocrites. You should be like Leonard Hand and Oliver Wendell Holmes and Felix Frankfurter, the old progressives, and you should reject, just like you rejected Lochner in cases like that, you should also reject Griswold, Roe, etc. In fact, Chief Justice Rehnquist, when he was a law clerk in the 1950s, wrote a memo to Justice Jackson, which he claims was reflecting Jackson's opinions, or at least was playing devil's advocate for Jackson, which no one believes, and I think is unbelievable. And he said, if we invalidate segregation here, we're acting just like Lochner. He spelled Lochner with a K, so he probably wasn't that familiar with it, but just like Lochner. So what we've had in constitutional law, at least until recently, is the debate, especially with regard to the 14th Amendment, has been between the old progressives, whose ideology has been picked up by Bork, Scalia, sometimes Thomas, at least with the due process clause, and others, and the new progressives, who accept the old progressives' view that we should never invalidate any economic regulation, but accept also modern liberalism's view, but we must protect civil rights and civil liberties. So what we're missing here is not just any point of view that would, in American constitutional history, be considered conservative or libertarian, but we're missing any sense like, hey, this is all just rhetorical positions that don't have anything to do with the actual history of Lochner and the progressives and the New Deal and all that. So the question then is, well, why do you care, Professor Bernstein, if this is the role that Lochner plays in constitutional discourse? The liberals use it to attack conservatives anytime they want to overturn any kind of regulation of economic stuff, and the liberals use it, conservatives use it to attack liberals anytime they want to find an unenumerated right to privacy, abortion, birth control. Now will be gay marriage will be next. We all know what that means. Why bother? Well, I think for two reasons. One is I get paid the big bucks to try to get to the accurate. I'm academic. My goal is not inherently to figure out, to support rhetoric one way or the other, to try to figure out what actually happened. But number two, I think that this whole reduction of much of decades of constitutional history into a rhetorical Lochner that each side makes up its own version regardless of what happened has really impoverished constitutional discourse. So instead of, for example, if a case involving Lawrence versus Texas, the right to engage in homosexual sodomy, when that came up, what does Justice Scalia say in dissent? He says, this 14th Amendment no more protects the right to engage in homosexual sodomy than it protects the right to work more than 60 hours in a bakery. Aha, see, you're just being like Lochner. Now, all right, very good rhetoric, but really, there's a serious claim here that people want to engage in sexual activity, which is very important to their sense of humanity, to their, obviously sexual activity is very important to people's sense of self, to their romantic life, to some of their most intimate feelings and emotions and so forth and so on, and just say, well, it's just like Lochner. Not a very productive argument, in my view. Similarly, if the Congress is trying to regulate possession of a gun near a school, as in the Lopez case, or trying to force everybody to buy health insurance, as in, of course, the Obamacare case, or any other controversial federal action that seems to create new powers, to say, oh, well, that's just being like Lochner. Doesn't really get to the argument, well, do we really think that the federal government has unlimited police power? Are there no limits to federal power? If not, what are those limits? Solicitor General Varelli, when he was asked, couldn't come with them, even though he was urged to do so by his subordinates, almost lost the case because when the court asked him, what are the limits to federal power? He said, there aren't any, basically. None that I could come up with. And that seems, but it seems so contrary to the constitutional text to say there are no limits whatsoever. The only way to get away with that is to say, well, if we found limits, it would be like Lochner. And that, once again, seems to me to be engaging in a very dubious shortcut, where there's a serious issue that the other side is bringing up. You should have some response to that. Instead, you're using this rhetoric. So I think a more accurate view of constitutional history will lead to a more nuanced, civil, constructive debate about modern constitutional law, and that's reason enough to rehabilitate Lochner. Thank you.
All right. So I want to start, before I get into my own words, with the words of someone else, and I'm not going to do much to explain them, but I hope over the course of my remarks, maybe why I started with it will become more clear. So I don't know how many of you know who Charles Hamilton Houston was, but he was the mentor for Thurgood Marshall, who helped start what we, sort of the modern NAACP Legal Defense Fund, and is really one of the architects of all the kind of litigation we associate with Marshall and and LDF. He died when in 1950, so he didn't get to see his work come to fruition. But he really helped put it all into place. And Houston taught what was probably one of the first law school classes on civil rights in the country, is my guess, at Howard Law School in around 1940. And I don't know, I wasn't there, but according to his lecture notes, one of the lectures he gave in the beginning of the class, in explaining to his students what civil rights were and how they worked, what he would tell them, and here I'm quoting Houston, was that civil rights, and here he was speaking about civil rights for African Americans, were luxuries extended the minority by the majority in an expanding economy. They would require, quote, a long record of persecution, and in order to succeed, those who were advocating for them would have to link them to, quote, the general problem of civil rights for America and all the world, whether those stemmed from repression of labor activists or religious minorities. So in Houston's view, African Americans would win civil rights not simply by litigating and going to court, though he did a lot of that, but by linking their fate to a majority that was willing to support their cause in a whole host of fora, far broader than in the courthouse. Okay, so I'm just going to just put that to the side for now, and now I'm going to get to the part I owe Lee, which is he last time I did one of these, he said, "Oh, you agreed a lot more than I thought you would." So I wouldn't want to let him down by not starting on that foot again, and say that there's much about Professor Bernstein's history I agree with, and in fact, I've relied on his work a lot in my own, and I think it's really important, the work that he and other legal historians are doing to give a more nuanced take on the progressive era. And so I just want to note a few of the myths he busted that I think he's totally right on about. So he is among a number of historians who've debunked the laissez-faire anti-economic legislation depiction of the pre-New Deal era Supreme Court, of that progressive era Supreme Court. And as he said, that court actually upheld far more state laws, economic regulatory laws, than it struck down. The rate of striking them down, some historians have documented, was rising during the period, but still the numbers and the proportion were still very low. And the court rarely struck down a federal statute like the Affordable Care Act that President Obama was referring to. So nothing very Lochner-esque certainly about that. These historians have also helpfully recovered how Lochner, as a decision, was little remarked on at the time that it was decided. Certainly not seen to be the watershed you are taught it was in con law usually, and its prominence as a symbol of what came before the New Deal really was a product of things that happened after the New Deal. So it's really it's sort of prominence as a symbol of the progressive era. Court is a product of mid-20th century law and politics, not progressive era law and politics. And one of your classmates is actually working on some research now that has shown how state courts, even after Lochner was decided, basically worked their way around it and continued to cite other Supreme Court precedents that preceded it in order to continue to uphold economic regulation. And then the last, and I think this is a very important one, as the dissent by Justice Holmes in Buchanan v. Worley really only begins to hint at, in the South, white progressives justified Jim Crow laws as just another way to ensure the public health and welfare. So certainly those progressive era liberals have a lot to account for in terms of their participation in establishing Jim Crow. So lots of myths that Professor Bernstein is, I think, quite justifiably busting and helpfully busting. But I also think myth busting can have the potential to produce new myths. So we bust one and we sort of produce another in its wake. And so I wanted to focus on one myth I think that could be in danger of being taken away from the myth busting that preceded me in my time up here. And that's to say that progressives were not at all concerned with civil rights and civil liberties. And I think that's an overstatement. Progressive justices, I mean, the most obvious way progressive justices such as Holmes and Brandeis did write dissents that helped generate what grew into the modern First Amendment doctrine you all learned today in law classes, but also in less obvious ways. So recent work, and this is something historians, really legal historians, are just starting to get a handle on, but recent work on civil liberties in this progressive era shows that it's really a mistake to counterpose what I would say maybe rightism and progressivism. And in fact, progressive valued especially civil liberties, but they had a state rather than court-centric idea about how these liberties should be preserved. So, for instance, there's a graduate student who's at Yale right now finishing up a dissertation and has a forthcoming article in Columbia Law Review about how Frankfurter, sort of an icon of progressivism, long before he got to the court, worked at the War Department during World War I, and while he was there, helped establish an extremely robust system for protecting conscientious objectors from having to serve in the military, which he saw as a way of preserving their civil liberties. And he had this. His idea was that you had these rights within the state. Similarly, there's been really interesting work being done right now on the early ACLU. ACLU was more allied with labor radicals than the government, and the early ACLU saw the bedrock civil liberty to be what they call the right to agitate, and they looked to legislatures, not courts, to recognize this right to agitate. For them, the apex of this recognition of this right to agitate was probably the early New Deal Norris-LaGuardia Act that restricted when federal courts could issue injunctions against strike activity. And I think these examples underscore that the debate that led to the Lochner myth wasn't simply one about economic liberties or not, and it wasn't just one for or against rights, but it was one about the respective roles of legislatures, the president, and courts, and what their respective roles should be in securing constitutional rights. Now, these debates, where to look for your rights, have been perennially coalition-splitting debates. In the heyday of New Deal liberalism, during the 50s, 60s, and 70s, some civil rights and labor advocates divided over whether it was the right thing to do to look to courts to police union discrimination. In the 1980s, this has also been a kind of a coalition splitting debate on the right. In the 1980s, right-to-work activists and Reagan administration originalists fell out over asking the Supreme Court to recognize the right-to-work movement's substantive due process and freedom of speech claims against private sector unions. And just as an aside, and another reminder that in these sort of genealogies of where rights come from and who ends up using them, rights are incredibly politically unstable. So these right-to-work claims that were being championed in the 1980s and are still being pressed, in fact, right now before the Supreme Court, trace back to those same progressive era dissents by Holmes and Brandeis. So, point is that this is as much a debate, not so much about rights or not rights, but about where you look for your rights. Who do you ask to recognize your rights? Are these rights that you look to the court for? Are these rights, as the progressives saw them, rights that were more within the state than against the state? And I think this is partly why Professor Bernstein refers to Justice Scalia and Judge Bork as old progressives, right? In some ways that dates back to that same time in the 80s when there was this falling out between rights activists within the rights litigators within the conservative movement and newly powerful originalists like Justice Scalia. And I think this tension between judicial deference to legislatures and the executive on the one hand, which I think often is associated with some of those old progressives, and a robust role for courts and rights protection divides modern-day legal conservatives too. And so in some ways, the debates that Professor Bernstein was setting up in the early 20th century are debates that don't just happen across the political aisle, but also often within each side of the aisle. So I just wanted to end with a couple of questions for Professor Bernstein to answer or not as you wish. But one was if Lochner was really the exception, not the rule in striking down legislation, what would revitalizing Lochner today accomplish? So what, because in some ways, by rehabilitating the case, you sort of debilitate the myth of Lochner as actually being all that much legally in the end at all. So I guess I'm curious what the rehabilitating Lochner as a doctrine and sort of sweeping away all the mythology around it would actually accomplish. And particularly, the title of the talk I had was Lochner for the Little Guy, and I guess I'm curious what little guys or gals you think would particularly benefit from doing that, and what laws you think would be most vulnerable, and whether, who you see as the greatest barrier to rehabilitating the doctrinal side of Lochner, if it's the conservative old progressives or the liberal new ones.
Thanks, Sophia. And I should say that I'm tickled to hear there's a lot that I know about some of the research that you're referring to, but not most of it actually, because I don't keep up with the graduate students, right? But one of the remarkable things in doing this research is, I discovered, was how little historical work there is on the transition from progressivism to modern liberalism. I asked a historian at NYU before I wrote the book, I said, am I missing something? Because I've done a literature search, I can't find it. He's like, nope, it's Laura Weinreb, and that's about who you obliquely referenced, and that's about it. As for the questions, I mean, I'm not, I have my own, I have very strange views on constitutional law. I shouldn't be. I don't know. I hope this isn't being recorded for some reason. But I've almost come to the conclusion that I've become something of a historicist, really, on it. And basically, I feel like whatever the Supreme Court does at any given moment is right in a sense, because the Constitution, as any legal document, is not really frozen in time, but it's just subject to the interpretations of those who are in charge of interpreting it. And it was meant to be a political decision because the justices on the court are appointed by political parties with political influences. So, I can't tell you, I think, this is what should happen. But I have my political preferences of what I like the court to do or not, which is really what it comes down to for most people ultimately anyway. But so again, my point there is that I try to very much separate in when I wrote this my own personal views of wouldn't it be nice if the court did this from just making the historical point. I do think it's true that if the myth of Lochner becomes less prevalent, that would reduce the reluctance of courts to protect some economic rights. I suppose that, although it might also reduce their unwillingness to protect other kinds of rights, because part of my point is, these rights weren't just made up in the 1960s by the Warren Court and by modern liberals. They actually have antecedents. We have this long natural rights tradition that arbitrary deprivations of rights are unconstitutional under the 14th Amendment, and cases like Griswold or Brown or all those, they were novel in that they extended things and and all that, but they all have their antecedents in a much different era, which may show that they have more staying power than modern conservatives like Bork might have thought. But to actually get to the answer, then, I think if things were to, I don't think, you can't go home again. We're not going to go back to 1905. Supreme Court isn't going to be striking down maximum hour laws. But what the Supreme Court has been doing since the 1950s is they've been applying a rational. They don't say there's no such thing as liberty of contract. They say there is liberty of contract, but we subject restrictions on it to a rational basis test. And when they apply the rational basis test, as a friend of mine likes to say, the rationale by the court doesn't have to actually be rational. It doesn't have to be the actual basis of the legislation, right? So there's rational basis testing. Let's look to see if you could actually articulate a rational basis. And there's a rational basis test that says, we don't care how ridiculous your rationale is and whether it had anything to do with legislation, we'll just accept it because we've just gone out of the business of reviewing these things. And that does have some implications. I think that the strongest Anglo-American sort of liberty of contract tradition is the anti-monopoly tradition, which goes way back to 1689 and the Statute of Monopolies in England, trying to prohibit the government from giving the king from giving his favored acolytes various monopolies like the British East India Company or Pennsylvania or whatever. I think, and you need, so you have that tradition, and you need someone who's actually agitating, and you have a group called the Institute for Justice based in D.C. that's agitating, and what they're trying to do is get the court to take some kinds of laws, particularly those that create monopolies against the little guy, to actually look at it as a real rational basis. They have cases like someone teaches themselves flower arranging, and then it turns out that the Florist Association goes to the government and says, hey, in our state, you actually need to pass a two-year apprenticeship program and take an exam, and then subjectively show us that you know how before you could call yourself a florist or flower arranger. Now, what public health, safety, other rationale, even fraud, someone doesn't do the flowers nicely, they go out of business very quickly. There's no plausible rationale for this other than we're protecting incumbent flower arrangers from others, right? And in that particular, in at least one of those cases, that's what the government said finally. They said, we don't have a basis for it except we want to protect incumbent people who lobbied us. And that should be good enough because the government has gone out of the business. The courts are out of the business of reviewing this stuff. And I don't think anyone, other than the problem of, you're reviving Lochner. I think if we weren't so worried about reviving Lochner, no one on any part of the political spectrum think it's a good thing for incumbent people in their field to keep out the little guy, the newcomer, the person who wasn't grandfathered in when they started licensing people and make the 2-year test. So there you have a really good example. There's no public health safety. There's another case they have, which is a circus split on now, actually. Do you need a license to sell caskets? Not to be an embalmer, not to bury people, not to run a funeral home, but just to sell the box. And in that particular case, the government came up, it was in Nashville, I believe, with ridiculous rationales. Well, maybe if you don't know enough about embalming and all that, and you'll sell the casket, you'll sell the wrong kind of casket, and somehow the casket will leak, and the people's remains will get into the water supply. And what was really bizarre about that is that in Tennessee, you don't need to be buried in a casket at all. There's no law saying you have to have a casket. So what's the difference? So there is just a completely implausible rationale. In that case, and they're very good at picking good plaintiffs. That case was an inner city church. They thought that their constituents were their congregants were being ripped off. People are upset when when someone dies, that funeral home owners were taking advantage of them and selling them overly expensive caskets. So we're just going to have our own, when people's relatives die, they can come to church, the minister will sell them a casket at cost, and so there are two examples. So there are the two things that I think could be revived. One is, if the government only rationale they could come up with is, we're trying to protect incumbent occupants of this field. Is that a plausible rationale? And number two, if the rationale is so implausible, doesn't make sense given the state's own other regulations, like the casket makers. I don't think that would be that big a deal. I think the bigger deal would be, maybe get rid of the myth of Lochner, make us fear judicial review a little bit less, which might have all sorts of unintended consequences. But there, and the other thing I could say is that after the Supreme Court dispensed with Lochner, until about 1973, when Roe v. Wade came out, there were quite a few state courts that were more conservative than the Supreme Court, and many of those courts, even today some state courts, still applied some sort of real rational basis scrutiny to economic regulations. And you never hear about these cases, right? Why? Because they're not a big deal. The court isn't striking down like core social welfare legislation. They're striking down marginal legislation. The only example I can think of where it became a big deal was when one state attorney general, who was kind of libertarian, said, you know what, under our state constitution, you actually can't give money to the Denver Broncos to build a new football stadium because you're not allowed to give money to private companies. And there was such a huge political uproar about that. God forbid you should interfere with the football season and our team. That one, actually, the attorney general had to back down. But beyond that, these cases do actually still happen, and you don't really. So I don't think it would make that much of a difference, really. I think, again, the broader difference would be that a lot of fear and loathing about judicial review comes from this myth that you had this out-of-control Supreme Court that was enforcing an unpopular ideology just by force of its own will, again, and striking down all sorts of crucial social welfare legislation, contrary to popular opinion, legal opinion, common sense, any kind of mercy that anyone might have, all this stuff. And once that gets dispelled, you could have you might have less hostility to the notion of judicial review, I suppose. But you could still, I would still say you could still say, yeah, that's all well and good, but I still think I'd rather, it doesn't mean that you can't still be opposed to judicial review even then. Just do it based on the actual facts, not on the myth. Anyway, I should stop talking and let there be a couple questions at least. Questions? Remonstrations? Opposition? Yes.
Question. So you've been talking a lot about rights, and I know that sometimes Lochner is viewed as the triumph of, I think it's Justice Fields' dissent in Illinois v. Munn. And my question, I guess, is just how much of this has to do with where the court decided to find rights? I mean, Fields' argument was that the privilege and immunities that Americans have in the 14th Amendment is where incorporation occurred. It happened all at once, whereas the court decided to pursue due process. And how has that decision, I think, kind of fortified by Lochner, affected the way rights are viewed in the United States?
Okay, well, you've opened a big can of worms there. That's a very so there's the privilege or immunities clause would seem to be the natural home for finding substantive rights under the 14th Amendment because it talks about privileges and immunities, which seems a lot like rights. But the 14th Amendment, but Slaughterhouse case in 1873 basically dispensed with that. So one problem is that rights have been found to be in this due process clause, and due process sounds a lot like procedure, and not like rights. And that gives opponents, both 100 years ago and today, a very good rhetorical hook. John Hart Ely famously said that substantive due process is like green pastel redness. It's a contradiction in terms. That neglects the fact that at least by 1868, there was a significant tradition that due process of law wasn't, now we're all positivists, so it's hard to conceive of this, but it wasn't a purely positivist conception of law, that the government says it's a law, it's a law. There was this idea that due process of law, for something to be a law, it couldn't just be arbitrary or will, or, and the courts would give examples. You can't just take, someone's property from A and give it to B for no reason. You can't just, you can't order a new trial after someone's already been acquitted. You can't have the executive also be the judge, and so forth and so on. Those things, they may be legislation allowing this, but it's not law, so it's not due process of law either. Now, whether that encompasses liberty of contract is a different point of view. But what I want to, but the other, so due process of law had some substantive component that almost everyone recognized by the 1860s. And the reason I can say almost everyone is if you go back to the debates between the abolitionists and the pro-slavery forces, they were both using the due process clause for the constitutional arguments. Famously in Dred Scott, Chief Justice Taney said that you can't ban slavery in the federal territories because then if someone from the South brought their slave in, you'd be taking their property away without due process. Meanwhile, though, Abraham Lincoln and the Republican Party were arguing that you can't recognize slavery in the federal territories, and the federal government can't recognize slavery anywhere. States are a different matter because that's federalism issues, but the federal government can't because there's a Fifth Amendment due process clause that applies to the federal government, and if you recognize slavery federally, you're taking away the slave's rights without due process. None of this was about judicial procedure. It's all about substantive rights. So everyone recognized there's some substantive aspect, but it has been a problem rhetorically because due process doesn't sound like it has anything to do with rights, with substantive rights per se. But the other thing I'll mention is that we often anachronistically think about the cases like Meyer versus Nebraska or the early free speech cases from the 1920s as being early incorporation cases, but they weren't. Incorporation was a 1940s and 50s innovation. The court was just saying, this is what due process of law protects. We don't distinguish between substantive and procedural, just whether the law is arbitrary or not. That was, again, so we have a lot of anachronistic views of the way due process of law came to be seen by modern liberal jurisprudence. We sort of go back and attribute that to the Lochner people, but they actually they didn't call substantive due process, they didn't believe in incorporation. It was all a question of what rights are protected by what fundamental individual rights are worthy of judicial protection, free speech, liberty of contract. If they happen to be in the Bill of Rights, that's great, but not all rights in the Bill of Rights are protected, and not all rights that are protected are in the Bill of Rights. Other questions?
Do you have any questions you want to pose?
While you were away, I posted a whole laundry list of them.
Okay, well, we don't have to stay.
Okay, well, thank you very much.
Thank you. Do you have copies for sale?
Yeah, I forgot to bring them.
Okay. Well, this is the time that we actually try to end, so we're on time today. Thank you all for attending. Next week we have two really great events. Monday we have Judge Bea of the Ninth Circuit. He will be speaking on racial preferences in education. He's a very interesting speaker. You won't want to miss that one. And then Wednesday evening, a rare Federalist Society evening event at 5 o'clock, we have Daniel Hannan, who is member of European Parliament for Southeast England, speaking on his new book, which is Inventing Freedom. It's an argument about how English-speaking world has kind of uniquely been promoting freedom in the history of the world. So definitely come out to that. We'll have a hoity-toity reception with beer. I have to say the word beer because that'll actually get you to come. And that'll be 5 o'clock on Wednesday. And of course, we'll do all our normal Facebook and everything else. Thank you.